All right, we are going to get started. Hello, everyone. Thank you for joining us on the webinar German Companies Before the U.S. Courts, Practical Tips to Protect Your Business Before It's Too Late, in partnership with Kilpatrick Townsend in Stockton. My name is Thais Voot, and I'm the events manager here at the GACC SAF. And before we get started, I'd like to go over a few housekeeping items. We encourage you to ask questions, so please use the questions function. We hope to answer them either throughout the webinar or at the end. Lastly, this will be recorded, so don't worry about taking quick notes. We will share the recording with you afterwards. And yeah, now with all of that said, I'd like to hand the floor over to Sigmar.
Thank you, Thais. Again, welcome to our presentation, German Companies Before the U.S. Courts, Practical Tips that my litigation partner, John Jett, and I will present in the next hour or so. And we'll share some of our experiences working with German companies in the U.S. for many years. And just a few words about myself. I'm a corporate partner in the San Francisco office of Kilpatrick Townsend, and I'm also admitted to practice law in Germany, and I've for many years now represented German companies either coming to the US or corporations that are owned or headquartered in Germany and do business over here. And with that, I'll hand it over to John. Maybe, John, do you want to say a few words about yourself?
Sure. Thanks, Sigmar, and thanks, everybody. It's great to be in front of you. As Sigmar mentioned, I am a business litigator, a partner in our Atlanta office, and I've also worked with a number of German companies and their subsidiaries in the United States regarding that they've had. My own path to appreciating Germany and German culture started more than 20 years ago when I was an exchange student in Germany. For those of you who can make sense of this garbled statement, ich war Austauschschüler in Potsdam, and that was a really great experience for me, and it is something that I think continues to inform part of my practice. So it's great to be with you here today.
All right, and with that, we'll here's our contact information. Here's a little bit about Kilpatrick Townsend. As many of you know, we're one of the larger firms in Atlanta, founded actually in San Francisco, and today we have about 20 offices across the United States and an office in Stockholm and in some offices in Asia. But with that, maybe just a quick overview of what we want to cover with you today. First, we want to identify risks for German companies in the U.S. legal system, but of course, as John will explain, don't be afraid of American civil litigation, and maybe some of you already are experienced with lawsuits in the US, but we would like to alert you how it works and maybe also what can be done to mitigate any risks. And that's the second part, take preventative action now before you get into litigation to, for example, mitigate the day-to-day risk, how you write emails, but also the big picture risk in the long run. What can you do in your contracts today or also in your corporate structure, including the transatlantic corporate structure, to be best prepared for potential litigation in the future? And with that, we'll kind of go through these points with 9 practice pointers, basically 9 tips that we will share with you based on our experience representing German companies for many years. Yeah, and with that, we will just jump right into it. And John, based on some of the litigation experiences he's had, developed this hypothetical, a case study in risk mitigation for German companies, and he is calling this Eagle Inc. versus Adler USA LLC. And maybe John, maybe you want to share what the hypothetical is about.
Thanks, Sigmar. Yeah, sometimes some of the principles and ideas and processes in American civil litigation that we're going to talk about today come out well with a little bit of a story. So as Sigmar mentioned, we've put together a bit of a hypothetical that maybe sounds somewhat familiar to some of you in the audience. We're imagining that Adler USA is the US subsidiary of a German parent. We're imagining that Adler USA has its headquarters in San Francisco, where, as Sigmar mentioned, he practices and we have an office. And we're imagining that Adler USA distributes sensors across the United States, which are very valuable components in our hypothetical, and that are used by other companies in their own businesses. Adler USA uses Adler SA's intellectual property, and it also uses some key personnel who visit from time to time from Germany. In our hypothetical, we're imagining that several years ago, Adler USA engaged a US company, which we're calling Eagle Inc., based in Atlanta, to explore integrating Eagle's proprietary technology into the packaging of Adler's products that are distributed in the USA. Eagle considers its technology very valuable, and it is a closely guarded secret of Eagle. And with that fact pattern, you can imagine that oftentimes in these sort of licensing and sharing arrangements, particularly where one party is having to rely on information that it considers very valuable and the secrecy of that information being very important, it's not unusual for disputes to arise about how that information is being used. So in our hypothetical, Eagle is alleging that Adler USA breached a contract between the parties and misappropriated Eagle's proprietary technology. And Eagle is going one step further and saying that that bad act by the US subsidiary was directed by the German parent company, which is also a pretty typical way that these suits will unfold. When Eagle files its lawsuit against Adler, it does a number of things that we're going to talk about. It demands a jury trial, asserts a wide variety of claims under different states' laws and under US federal law. It seeks a lot of money, and it seeks to enhance the amount of money that it might receive in order to punish Adler. It also claims that it should be able to recover its attorney's fees. So it's availing itself of a number of sort of interesting features of US law that are sometimes unfamiliar to individuals doing business in the United States who are not from the US. So we look at one of the first issues raised in our hypothetical lawsuit. The people at Adler would potentially ask their lawyers, can we really be sued in Georgia state court? You remember in our hypothetical, the German parent is obviously located in Germany, and the German subsidiary operating in the US is based in California. So how could they ever be sued in Georgia state court when their sole relationship to Georgia is their business dealings with Eagle? And they might find themselves asking, what could we have done to avoid this situation where we're facing a lawsuit in Georgia? One thing from a litigation perspective that we sometimes look at is taking a case out of state courts and putting them in federal courts. The idea being that the federal courts will have less of the sort of local prejudice against foreign companies that you can see in some state courts, arguably, depending on who you ask. But there's also some things you can do by working with your transactional lawyer, with someone like Sigmar on the front end, to address this kind of issue before you find yourself in a state court. So Sigmar will talk about an example that illustrates this and a possible solution which you can consider on the front end to minimize your risk.
Yes, thank you, John. So the way we want to do this presentation is John lays out the risks that occur or things that is developing in the litigation, and then I'm gonna join in every once in a while and say how this could be prevented on the corporate side or contractual side. And one of the examples is the jurisdiction clause that, if it's properly drafted, can really be helpful And of course, that's one of the clauses that a lot of people just read over towards the end. But here's a great example of how a good jurisdiction clause helped a German company, and that's the recent case of American Telecom versus German Telecom, which was actually brought in the federal court in Washington, D.C. And that was despite the fact that the parties' agreement had chosen Bonn as the venue for disputes. But the American company still decided to file the lawsuit in its home court, thinking it's more advantageous. And there are other things that we're going to talk about, discovery, that might actually be more advantageous. But the American court dismissed the case for lack of jurisdiction, which is, of course, what the German Telecom wanted. But in addition, and that's probably the real special feature, when the court was dismissed the case and the case was brought in Germany, the German court then awarded Deutsche Telekom $200,000 in attorney's fees, which were incurred in defending the US action that was filed in violation of the venue clause. So the German court said, well, look, this was a clear, an unambiguous venue clause, and you still brought the case in Washington, D.C., so now you have to reimburse the attorney's fees. So that's sort of the somewhat obvious, but first practice pointer here, have an exclusive place of jurisdiction and stipulate that in your contract very clearly from the outset.
Another question that you might have, and something that we found surprising often for those outside the United States who are litigating for the first time in the United States, is to see a wide variety of claims that can be asserted. And it would be very typical for a plaintiff to sort of take a shot at borrowing the laws from a number of different states, as well as federal claims, in order to sort of put together the most favorable set of claims that they could. And so that can make for much more complicated litigation. But as we just talked about with the forum selection clause, there's also the possibility to address this when you're working with your transactional lawyer. And Sigmar can speak a little bit to some of the preventative measures that can be handled in front-end contracting.
Yes, thank you, John. So the next clause that sometimes is either just copied from another contract or read over is the choice of law clause. And it's important for matters like this one that the choice of law clause is drafted properly. And as you can see here on the screen, I highlighted one of the clauses, or one of the phrases in the clause that's often overlooked, is that you're choosing the applicable law not only for the actual contract and the breach of contract matters, but then for all matters arising out of, or even broader, relating to this agreement. And that's important because that would then also include torts or other acts that are basically committed in the performance of the contract, and not necessarily just a breach of contract itself. So that'd be a broader choice of law clause, and the properly drafted clause will definitely help you in cases like this one, as John just described. So practice pointer, like we just said, exclusive jurisdiction clause, properly drafted will help you, but then also a properly drafted broad choice of law clause will help you, especially if you want to rely on a certain jurisdiction, for example, either Georgia or California, or also internationally, for example, German law.
Thanks, Sigmar. So another issue in our hypothetical that we saw is that Eagle is able to make sort of broad and vague claims that it believes that Adler has misappropriated its trade secrets. And this, again, isn't something that's really necessarily good or bad. I mean, it may be that some of you on this call find yourselves in a situation of wanting to be the plaintiff and wanting to keep your claims maybe less detailed. Certainly there's many plaintiffs who have legitimate reasons for wanting to do that. But what's interesting is that can differ from maybe what some of you are accustomed to if you've had experience with the German system, because in America, the approach is to undertake what's called notice pleading. It's sort of what is required to provide notice to the other side of what the claims are about, to sort of highlight the issues and what discovery could possibly prove or disprove the facts and contentions that are at issue. And I'm a little out of my depths here, but I'm lucky to have Sigmar with me, and I understand that in Germany the approach is different, with fact pleading, where a German judge would take control of a proceeding very early through a very rigorous process to narrow the case at the front end. And that's just not something that is typical in the U.S. system. We'll talk a little bit about motions to dismiss, which is a way that courts will look at cases on the early end, but that is a much less hands-on process than the sort of fact pleading approach that some of you will be familiar with from Germany. You see here just a sort of example of a complaint. It's not unusual for us to have complaints that are very short, just a number of pages and a handful of pages, and that will be seeking many millions of dollars. Again, the idea being simply to put the other side on notice about the claims that will later be proven through discovery. One thing that can sometimes be of concern for people when they receive a lawsuit, particularly where it involves technical subject matter, as in our hypothetical here today, where we're talking about proprietary technology and a company that manufactures sensors, there'll often be a discomfort level around having non-experts looking at the questions in dispute, the idea being that only engineers or industry professionals could really understand the underlying technology and therefore could avoid being confused. The American approach is to sort of trust the common sense of lay people who are brought in as jurors, and the burden is placed on the parties and on their lawyers through testimony and through expert testimony to sort of make things understandable for the jurors. And so it certainly has a lot to say for it to be very effective, but it is something to be aware of, because it is a surprise for a lot of people when they consider how complicated their business is, having to present it to people who are going to come to the case in almost every instance with no pre-existing knowledge of what's at dispute in the case. But to kind of keep the theme alive, if that's not a situation that appeals to you and you would rather have experts and those steeped in your industry decide any disputes that you may engage in a commercial case, then again, you can work with your transactional lawyer to address that on the front end. So Sigmar, do you want to speak a little bit to some of the ways that you try to address those kind of concerns?
Yes, sure. So again, in the contract that you negotiate to cover this situation, you could either stipulate arbitration, where you could say, look, we're not going to resolve disputes in front of a jury, but we will arbitrate any disputes, and then you will also determine whether there's a sole arbitrator or a panel of arbitrators, or even you could determine experts or a method of how to determine experts, or the arbitration court will do that for you. You could also try to waive the jury trial in the contract already, and that's one of the two ways to best address this at the outset. So that leads to our practice pointer number 2. Consider adding a waiver of jury trial in your contract, and then also consider an arbitration clause in your contract. And that could be, AAA arbitration, JAMS arbitration, or if you're able to, you could also use Deutsches Institut der Schiedsgerichtsbarkeit or other arbitration courts over in Germany.
Thanks, Sigmar. Another thing that will often stand out to people about the American civil system is an aspect of damages that's available in certain cases in which the defendant, because of their alleged wrongdoing, if it's proven, is going to be punished beyond just compensating the plaintiff, and that's punitive damages. And the point of those damages can, in certain circumstances, be also to make an example of that defendant, to have a deterrent effect among others who see that result and are thereby discouraged from the same bad behavior. Those numbers can be somewhat eye-popping in their size, and I think we'll look in a little bit at a number of results. But it is worth appreciating that those kind of claims do exist out in the world, whether you're the plaintiff seeking them or whether you're the defendant disproving why those are applicable to you. It is a feature that can make U.S. civil litigation much higher stakes. In much the same way that we spoke a moment ago about notice pleading in complaints in the United States, there's not a requirement at the early stages of an American lawsuit to specify in any detail what the damages will be. And so it would be very customary for you to see language like we have here in this slide, that Eagle is just seeking more than $25 million and an amount to be proven at trial. And so in many respects, you may not know until you get deeper into the case, or even until you get to trial, exactly what your full exposure in a case might be as a defendant, or as a plaintiff, what you might ultimately be entitled to. There is a kind of a wide degree of flexibility in those numbers. But in general, damages, the most sort of standard damages in the U.S. system are going to be things like lost profits, unjust enrichment, sort of the thing that someone obtained through their wrongful actions. That's the sort of key aspect of damages in American civil litigation. But at bottom, I just excerpted this sentence from a decision in a case, and it just explains that in a trade secret case, computing damages is not cut and dry. And I think many litigators in the U.S. would agree with me that that principle generally holds true across a lot of litigation, that there's a degree of unpredictability or flexibility in damages awards, something for you as a plaintiff or you as a defendant to be aware of. And as we talked about, I mean, it is possible in these cases for the damages to be tripled or for there to be additional damages tacked on. And you see that here in our chart, which shows these are not typical, but they're also not unprecedented. Every year there will be significant awards like you see here made. So in the right case, where the transactions were large enough or where the intellectual property were valuable enough, very substantial amounts of money can be at issue. And Sigmar, do you want to talk a little bit about how you try to minimize that risk on the front end in your contract?
Yes, and that of course only applies, like John said, if the matter is actually governed by a contract. So in the contracts, as you probably have seen in the small print, it's in many contracts, you can include limitations of liabilities clauses. For example, you can try to cap the amount on both sides. The maximum liability for any matters under this contract will be capped at X. Then the other category that you've probably seen is you can exclude certain types of damages. For example, punitive, consequential, indirect, and so forth, which could be an effective protection, again, only for matters that are governed by contract or governed by the contract clauses. And then the third point is to protect yourself could be to consider liquidated damages. Liquidated damages would be basically fixed agreed amounts of damages for certain types of harm that is being inflicted you can often find it in connection with breaches of confidentiality or trade secrets, where it's sometimes very hard to prove what the actual damages is, what the actual damage is. So you could say, if this occurs, this type of breach occurs, you will owe this amount X, which will make litigation shorter because you don't have to argue over these amounts, and then we'll also give you some protection in case you're the party that is being harmed, that you will actually receive some money that otherwise you couldn't really prove that the actual damage occurred. So those are three types of limitations of liability that you can include in your contract.
Thanks, Sigmar. Another aspect of American civil litigation is how attorney's fees are addressed. And it's my understanding that in Germany, it's typical for the loser to be required to pay fees and costs. The default American rule is for each party to bear its own fees and costs. And there are certain statutory claims. For example, we've talked a little bit in our hypothetical about trade secrets types claims. There's a federal trade secret law that would provide for attorney fee shifting, but that's the exception. Most claims will default to this rule that each party bears its own fees and costs. But as we've talked about with so many aspects of the system, this is something that working with your transactional lawyer, you can address on the front end. And I'll turn it over to Sigmar to talk about that.
Yeah, so a lot of our German clients just say, well, let's put that clause in if they even think about, that there is a difference in the fee-bearing provisions of the applicable law. Let's just put in that the prevailing party in the lawsuit will be reimbursed or will receive their attorney's fees by the underlying party, and then sometimes you can either say, the reasonable attorney's fees or the actual attorney's fees, even if they're excessive. So that's something that you could put in to sort of mimic what German law does, at least in most instances. But again, you might want to think about if you really want to do that, depending on your contractual relationship, that may actually hurt you or help you. It could also be, that the contract is set up in a way that the risk is mostly on one side, and you really have to think about who is more likely to have to sue and how risky is that lawsuit in terms of will you win or will you lose, and then decide if you want to include a fee shifting clause. So that's, again, practice pointer number 4. Think about fee shifting clauses, and that fee shifting is not and that the prevailing party doesn't automatically get reimbursed for their attorney's fees under US law.
Thanks, Sigmar. The next thing that sometimes comes up in civil litigation, particularly when we're dealing with individuals from Germany who are litigating for the first time in the United States, if they're the defendant and the sort of situation arises as we've described in our hypothetical, where Eagle is alleging that Adler USA's bad acts were directed by the German parent company, that can often be upsetting for those in the US subsidiary and the parent company to see that and to see potential exposure for the German parent. And often people will react, as we've got in this text bubble here, they'll see that as harassment. And I guess, it's possible that it could be being done for harassment. It also often stems from people just not being sure who they need to sue. But it is an issue that we often have to work through in cases involving foreign entities. Part of the analysis that will go into whether it's appropriate to have the German parent as a party in a dispute like the hypothetical that we're discussing is to understand how realistic is it that Eagle will be able to make out that Adler is the agent of its German parent. That is it acting at the specific direction of its German parent? Or similarly, is the degree of overlap between the companies such that the subsidiary could be considered legally the alter ego of the German parent? And those are fairly involved legal concepts that can be very hotly contested But they really break down a lot to the degree of corporate separateness between the subsidiary and the parent. And so you're less likely as a parent company to be subject to jurisdiction when you don't have employees in the US, when you're truly working through the subsidiary that is independent of you as the parent, when the subsidiary's strategy, their distribution strategy most often, is not controlled by the parent. Those are the sort of considerations that will feature very prominently in the analysis of whether a German parent can be held liable. But a lot of it comes down to, as so many things that we're talking about here today, the work you do on the front end, working with your transactional lawyer and how you set up the companies. And so I'll turn it over to Sigmar to comment on that.
Yes, and I think that's really one of the biggest points, or probably the most important takeaway today is the corporate separateness. If you are talking about the German parent and the U.S. subsidiary, because one thing is to include in your contract certain protections, and we talked about these clauses that probably most of us are familiar with. But in terms of protecting a company, especially the parent company, which typically has sort of the deeper pockets and, like John said, is being pulled into the lawsuits for leverage, and also potentially because they can pay higher awards. This is a situation where there's no contract, and you can't really protect yourself with a contract if you're not even the party of the relationship in the U.S. But what you can do is protect yourself against liability, piercing the corporate veil liability, and also jurisdiction, to be even that a party in the US could even sue you in the US, whether or not you have a contract, by living the corporate separateness. And that means the subsidiary runs its own business. It is not an alter ego. It's not just an empty shell that is being directed by the parent company. There's ideally minimal overlap in the management. The Vorstand of the AG is not at the same time also in the board of directors of the subsidiary, and many other aspects. This is not a complete list. It's just kind of there are a number of issues or a number of topics that will have to be addressed, and there's an overall balancing test that will eventually determine if there is a piercing corporate veil liability. Again, that's very rare. The piercing, like in Germany, is very limited. It's limited to extreme cases, but if a plaintiff in the US asserts this, you want to be prepared and be able to show that both entities were in fact independent corporations or companies.
So as we continue to look at this question of the German parent's possible involvement, and questions that we typically will get will relate to, can the German parent, is this even possible? I mean, is it even possible for the German parent to be brought into a US-based lawsuit? And the answer, in short, is going to be it depends, but potentially yes. And one of the main issues that will come up will be around service, and again, this jurisdictional question. And so we'll turn it back over to Sigmar for that.
Yeah. So again, to the point of jurisdiction, it's less likely that a court would find to have jurisdiction without contractual jurisdiction over a German parent if the parent doesn't have any employees in the United States. Or, of course, the flip side of that is if any employees are really employed by the U.S. subsidiary. If the parent works through a subsidiary, then that entity should be independent. It could be a nationwide distributor for the German manufacturer, but it does have to be independent. And there should not be control, or the term is excessive control by the parent, which is a concept that's sometimes invoked to show that the subsidiary was in fact an empty shell, or really only the alter ego of the parent. sort of the jurisdictional analysis is somewhat parallel to the piercing the corporate veil analysis. So you do have to show that there is no, or the plaintiff would have to show that there is excessive control, and you'd be surprised what shows up in complaints as an indicator of that control. And we'll talk about discovery in just a minute. But yeah, try to avoid excessive control. And the other thing is, if the German parent does get served with a lawsuit, or if a plaintiff tries to serve the German company and tries to pull it into the lawsuit, the proper service is through the Hague Convention, a treaty that includes a process with several steps of how the governments basically work together to effect proper service. That is time-consuming and a little costly. It's not too costly, but there's several steps, and going through that process can be a deterrent for plaintiffs to try to serve the parent. So one thing you may want to consider, if you hear about the complaint, don't just say, oh yeah, we got it and we waive service, unless you want to do that, because it will be more difficult to serve through the Hague Convention, and that could be a deterrent, and you may not waive that additional hurdle, so to speak.
So after you've gotten the complaint, the next step, whether you're the plaintiff or the defendant, is in many instances, there's likely to be a threshold motion to test the plaintiff's legal theory in a case. This is a less intensive process than what I understand happens in Germany, but the judge will still look at the legal theories and see whether they are plausible. Generally speaking, probably the tendency is to allow people an opportunity to explore their case and to try to build it out through discovery. Some cases do fail at this motion to dismiss stage, but in our hypothetical, the court decides to allow Eagle to have some discovery on its merits claims, as we call them, its claims of misappropriation of trade secrets. Similarly, in our hypothetical, the parent company moves to dismiss for lack of personal jurisdiction, saying it doesn't have enough of a tie to Georgia to be sued there. And a typical thing for the court to do, and all of these things are fact specific, but it would not be surprising for a court to allow some limited jurisdictional discovery of Adler to test the degree of its connection to Georgia, whether it would be appropriate for Adler AG to have expected to be sued in Georgia. When the discovery process starts, this is a part that will often get a lot of people's attention because it can be very broad, very burdensome, and very expensive. Again, whether you're the plaintiff or the defendant in a corporate business dispute. And we often tell clients that litigation in the United States is sort of the sport of kings. It can be truly expensive. And so one thing to consider, I mean, I saw my friend and the lawyer that I litigated against, Andrew Flake, joined us today. Andrew has, in addition to his litigation practice, a mediation practice. That's something that can often make sense early in a case before you start to incur the expense of discovery, to see whether the parties can get together and find a business resolution early. It is not unusual for parties to get well into litigation and realize that the cost of the litigation itself is something that makes a business resolution more difficult, and they feel some regret that they didn't try earlier. So it's worth considering as a sort of a practice pointer that we don't have in our slide deck, but something for everyone to think about is whether you might benefit from the perspective of a third party early in the case to try to find a business resolution that you can live with, because the realities of American litigation is that it can be very expensive, very fast. And this, as you see on the slide, is one of the main reasons, is that there is a tendency to give people the opportunity to build out their claims, to build out their defenses through a sort of sweeping discovery of all of the documents, all the emails, all of the spreadsheets, all of the databases that may prove or disprove a claim or defense.
All right, and that leads to our practice pointer number 7. If you can, for example, in arbitration, stipulate the scope of the discovery. So if you include an arbitration clause, and like John said, just to add to sort of to the earlier discussion, some arbitration clauses, of course, also include mediation. They could be, it could be a 2-step process. First the parties, or often it's even a 3-step process, right? The management discusses if they can't resolve the problem, and then it goes to mediation. If mediation is successful, that's the end of the matter. If not, it will go on to arbitration. So you could, in your clauses, stipulate the scope of discovery to limit the work and the time and the money spent on it, if that's appropriate. But also, many corporations have document retention policies in place, and that could be even mandated by privacy laws, especially in Europe. But it will also help you to have in discovery, if you have a general policy to delete certain documents, certain categories of documents in your company after a certain amount of years. Often it's kind of it's a tiered system. Certain documents can be deleted after 2 years, some after 10, some after 7, depending on other, like for example, tax laws that require you to keep documents for a certain amount of time. But again, it also depends on what type of a company you are. If you get into litigation, having old documents could also help you defend your case. That can be the case for insurance companies, for example. So it needs to be a well thought out document retention policy that's applicable in general, and that has been in place before the litigation started. And then as you document anything in your company, you want to, in the US company, for the most part, but also in the German parent, if that's applicable, you want to be careful how you phrase your board minutes, thinking about excessive control arguments. You want to be careful how you phrase your intercompany agreements that many companies have for tax purposes, that can also be produced as part of discovery to show control. And then, of course, and John is going to talk about this a little more, how to phrase and how to word emails, your day-to-day emails, which he has seen can cause many problems in discovery and sometimes make or break a case.
Thanks, Sigmar. Yeah, it's something that, I wrote these and sort of made these up, but I have to say these are the kinds of emails that we see often and that will often cause some heartburn for people when they have to give a deposition or testimony at an arbitration or at a trial, because all of us these days have to send so many emails. But if you do take a moment to think about how comfortable you would be with the email being spread more broadly, I think it can be helpful, and just sort of how litigation and how your testimony goes for you, should that ever happen. And I think for most people in America, eventually it does happen that they have to give a deposition in one context or another. So this email here, that's part of our hypothetical, an internal email between Adler USA's CFO and their controller, in which they start talking about a separate deal, and they describe it as being top secret. And the way this would often come up in litigation is someone would tell me or whoever is helping them in litigation about how they really don't want the news of their potential strategic acquisition of Acme Corporation to come out. It doesn't really have anything to do with Eagle, and they just really don't want this information spread. But as you can see in this email, the email is also talking about Eagle. And so an American court would be very likely to require this sort of email to be turned over. And so the information about the potential acquisition of Acme, which is being described here as being top secret, would end up being shared. And again, that's just something that causes people discomfort when they have these kind of this kind of mixed message in a particular email. So when you do have things that are top secret, consider how you're going to put them in email with a view that we don't always know how emails will end up being produced. Similarly, another thing that we see come up pretty often in email productions that come out in discovery will be the kind of things that I think all of us do from time to time, maybe a little bit of venting, maybe being a little bit frustrated, maybe not choosing our words very carefully, and having an email that probably doesn't reflect our actual feelings, and certainly doesn't reflect our feelings 6 months or 18 months after the fact, when an email is being examined. And so it's just, again, something to think about, that when thoughts are put down on email, they live forever, and they can be sort of blown out of proportion in a later litigation. It's just something to think about. Lastly, and this is probably the hardest one to guard against, but in our hypothetical, an email here from Adler USA's Chief Technical Officer, in which he writes something that feels pretty innocent, just saying that Eagle's technology is really good and we can learn a lot from them. It's just, maybe there's nothing to do on the front end, but it's something to be aware of, that your emails can be taken out of context. Because in a misappropriation lawsuit by Eagle, when they get a hold of an email like this, they're going to argue to the judge or jury or arbitrator that this shows exactly why Adler would want to steal their technology, because Adler needed to learn from Eagle. Again, out of context, but the sort of thing that does come up in litigation, something to be aware of. And I think Sigmar is going to talk a little bit more about our thoughts on sort of email best practices.
Yes, so here's something, or practice pointer number 8, concerning emails. Apply what we call the New York Times test. So don't write anything into an email that you wouldn't want to be republished on the front page of the New York Times. And that's, I think, a good reminder if we write emails every day, and sometimes just to a colleague, or it's almost like a chat function on the side where like, oh, what do you think about that? Or that's really stupid. Stay away from that and think about, would you write this on the front page of the New York Times? And then also be careful with humor and sarcasm, and especially if this goes across the Atlantic. I think we all know that German humor is also different than American humor, and if something that was written in Germany will be produced in a US court, it could be misunderstood. And but even just within the US, humor and sarcasm is always risky, especially if it's then produced in front of a jury completely out of context. So be careful on these two fronts when you write emails to prevent bad surprises in discovery.
Another thing that will come up about discovery is, again, because the cost will really add up quickly, will be questions about whether there's any way for Eagle, make Eagle, or to make the party that's requesting a lot of discovery bear the cost of that discovery. And then similarly, something that we see often with those who have ties to the European Union will be concerns about the data privacy laws, the GDPR, and understanding how that applies to both the German parent and to the German subsidiary. I have to say it's something that is sort of unfolding in real time for all of us, with new cases coming out regularly as courts try to strike the right balance between the US court system's inclination to put evidence out in the open and allow a process to try to find the truth based on sort of all of the relevant evidence, versus also respecting privacy laws that are in place, particularly those that are abroad. So that's a challenge for the courts. Probably on balance, the way the courts in the US have been trying to handle it is through what are called protective orders that apply greater privacy protections to the documents exchanged in litigation, but still requiring the exchange of information, even if it would not be otherwise allowed, and also using ample redactions where that's a possibility to try to minimize the less relevant information that's exchanged. But it's a very challenging situation, and one that's probably best addressed through some sort of practical steps that I think Sigmar is going to talk about, and that he's helped counsel some German clients around. So I'll turn it over to Sigmar to talk about some practice pointers.
Yeah, so so the first point here on the slide is still pertaining to discovery. And if you can, in a contractual clause, you can also try to stipulate who bears the cost of litigation in case of disputes. I mean, that's very rare, but you could try to shift the cost of discovery to one party. And then second, some of the German management sometimes thinks, oh, well, privacy law will protect us, and in the U.S. courts cannot request us in discovery to produce these documents because they're obviously, you know, that's sort of the mindset. It contains sensitive information and can't be disclosed. But like John just explained, that's not the view, of course, that U.S. courts take, because there are certain protections that can, you know, like protective orders or redacting that can make the sensitive information or some of the documents that contain sensitive information discoverable. So a recent case just said, well, European privacy laws are not a talisman for preventing discovery. And I think that's sort of the key word to remember. It's not a talisman. The privacy laws, the European privacy laws are not always a guarantee that these documents remain secret. But as a practical matter, what we sometimes also see is that if the US subsidiary is being sued, that in discovery, the management of the US company is being asked to produce documents of the parent if, as a practical matter, they have access to it. And that happens if the US management is also part of the German management. And again, it's another reason to establish and maintain corporate separateness so that that representatives of the subsidiary don't even factually have access and can't even, as a practical matter, be required to produce those documents that are otherwise sensitive or also protected by privacy laws. Yeah, so that's our last practice pointer. So summing up what we discussed in the last 55 minutes or so, you know, what can Adler teach us? As many of you know, civil litigation in the US can be complex, unpredictable, it can be slow, burdensome, and can be very high stakes if you think about the amounts that we just saw. Prevention, of course, is better than cure. That's why we're all here in this discussion today. And prevention happens first in your contracts. So we discussed a number of clauses that you can include, but also have to be careful about how they're being drafted. And also if in this particular situation that you're in, that this contract is being drafted, does this kind of a clause, is that likely to actually help you? Or is it more likely that a situation comes up where this type of a clause could help the other side? So that's what you can do in contracts, and that, you know, also pertains to damages and limitation of liability. But second, and maybe that's even more important, is in your day-to-day dealings, practice corporate separateness. We saw a number of situations where that comes into play: jurisdiction, piercing the corporate veil, and even discovery. And don't exercise excessive control. What seems to be, in our experience, what seems to be normal in terms of reserved matters or transactions that require consent of the parent, what seems to be more normal in terms of governance in group companies over in Europe can be part of the balancing test that might lead to the conclusion of excessive control in a U.S. court. And then thirdly, in your emails, live by the New York Times test, and privacy law is no talisman. So that's sort of in the nutshell what we wanted to share with you today in terms of John's and my experience in advising German companies in the US. And thanks for your attention. Thanks for being here today. And I think, Thijs, we have a few minutes left in case there are any questions.
Yes, we have a few. So the first one is, what are the benefits risk-wise to set up a US legal entity structure as follows: Holding Inc. subsidiary Inc. versus Holding Inc. subsidiary LLC?
Yes, so I understand this is just a basically purely domestic setup.
Yes.
It sounds like it.
Yeah.
So I believe probably the question, I mean, the question is really about Inc. versus LLC in this case, talking about the subsidiary, and there are a number of aspects that can influence the decision if you have an LLC or an Inc. So the first and probably most important one is the tax difference. You know, an LLC can be structured as a tax transparent entity, meaning a pass-through entity, in which case no separate corporate level tax would be incurred on the level of the LLC. The other, you know, maybe more along the lines of what we discussed today, piercing the corporate veil. You know, can the Inc. be liable potentially for the debt of the subsidiary, in this case the LLC? So sometimes there's sort of still the question out there, if liability protection of an LLC is as strong as the one of a corporation, because the LLC is considered to be a more flexible entity, sometimes, you know, more like a partnership or informal, or even operating agreements don't always even have to be in writing. But that's generally not what we see anymore in the case law. So the liability protection of the LLCs is pretty much as strong nowadays as the one of corporations. So in that sense, there is actually not much of a difference from the liability perspective.
Sounds good. Thank you. And to kind of also bounce off of that question, so in the scenario where the parent company and subsidiary are not set up as separate entities, would you need a German practicing lawyer and American practicing lawyer present in the US?
So it's always good to have lawyers present, right? That's of course what we would say. So if the German parent doesn't have a subsidiary but does business in the US, that's risky for multiple reasons. And we just discussed the potential liability exposure to lawsuits, but probably most importantly, it's also potential tax liability of the German parent in the US. If you establish a branch without incorporating, you basically have a permanent establishment for tax purposes. And so the US IRS might start to look at your income. So that's one of the things. The other thing is liability protection. You know, a lot of the talk today covered how you can shield the assets of the parent by incorporating as a subsidiary. And I think part of the question was, does a lawyer have to be present? So you can incorporate without a lawyer, and so a lawyer doesn't have to be present. What we typically do if we advise companies to how to set up a structure, of course, we would collaborate and, you know, pick up the phone and talk to the German attorneys, see what, you know, special requirements they might be. Also talk to the German tax advisor, because that's also a big difference if you incorporate. So, but technically, no lawyer has to be present.
Okay, great. And then one last question that I see here: are there any additional legal considerations to be mindful of in terms of communications outside of work, such as email, personal email address, text messages, stuff like that.
Maybe that's discovery related, John. Is that something you want to address?
Yes, I mean, I think the question suggests the person is already thinking along those lines. I mean, the more different ways of communicating the person uses related to whatever the subject of the litigation is, the more risk there is that those types of communication are going to be searched for discoverable information. So I think that person's on the right track, thinking along those lines.
Gotcha. Well, thank you. Thank you both for sharing your insights today. I really appreciate it. And thank you to those who attended live. We hope you learned quite a lot. And if you do have questions for both Sigmar and John, their contact information is here on the screen. And if you come up with questions later and you would like an introduction, we're happy to make that. So we hope you continue to stay safe and healthy and have a great rest of your day. Thank you.
Thank you.